Go ahead and get your attention.
I do all the research in my life.
We'll get started here. Thank you all for coming. As always, we always appreciate having you. Before I introduce our speaker, I do want to just, as always, mention the upcoming events that the chapter has. On Wednesday, March 28th, which is very soon, a lot sooner than normal between our events, Ed Whalen will be here to discuss Scalia Speaks, the book he co-edited with Christopher Scalia, a collection of Justice Scalia's speeches. Ed runs the Ethics and Public Policy Center in D.C. and does a lot in the legal policy world. It should be an excellent event. I hope you can attend. If you are a student PED for this event, that doesn't necessarily mean you're on the list for that event. So if you do intend to attend that event, please let me know. Also, on Friday, April 6th, we'll have our second annual Ohio Lawyers Chapters Conference in Columbus at the Westin. As of yesterday, we finally finalized the full speakers list. We will have essentially 4 panels, and we are in the process of applying and hopefully receiving should be 4.5 hours of CLE credit, which is great for $50. The first panel on originalism and federalism, well, actually before that even, we'll have Chad Riedler, who is the acting Associate Attorney General. Many of you know from Jones Day, will give some introductory remarks. After that, we'll have a panel on originalism and federalism. The moderator will be Judge Greg Katsas of the U.S. Circuit Court of Appeals for the District of Columbia Circuit. The panelists will be Jonathan Adler, a professor of law up in Cleveland, Eric Murphy, our state solicitor who has spoken to this chapter many times, Peter Shane, a law professor at Ohio State, providing kind of the anti-originalist viewpoint. We'll then have a lunch discussion or debate on the Janus case, the Supreme Court case recently heard regarding public sector union fees and the First Amendment. Bill Messenger, who spoke to our chapter a couple years ago and who presented the oral argument on behalf of Mark Janus a few weeks ago at the Supreme Court, will be presenting his views on the issue, and Professor Camille Hebert, also from Ohio State, will be presenting the union's views on that issue. Robert Ault from the Buckeye Institute will moderate. We'll then have a panel on criminal justice reform, moderated by Ohio Supreme Court Justice Sharon Kennedy, Auditor of State and former prosecutor Dave Yost, Heather Childs, who is a in-house attorney at Capital One, but previously clerked for several judges and also served in the Justice Department, will be participating, along with Daniel Dew, who deals with criminal justice issues at the Buckeye Institute. And finally, we'll have a panel, or a forum really, at which all 4, both Republican and Democrat candidates for the Ohio Supreme Court will participate and answer questions regarding their views on judicial issues and the Ohio judicial system. So I hope you can attend. It, I believe, will be a wonderful event and certainly worth the money for the CLE hours. But the important thing is you do need to register online. It's important for us for many reasons to track who's going to be coming and to order food, etc. So if you plan to attend, please register. You can go to the Federalist Society's website, or I sent out an email last week. If you received that, there's a link in that email. So hope you can attend. That being said, our speaker today is Professor Josh Blackman from South Texas College of Law, Houston. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He's also the author of Unprecedented, the Constitutional Challenge to Obamacare. He was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He's testified before the House Judiciary Committee and other organizations as well. He is an adjunct scholar at the Cato Institute. He's the founder and president of the Harlan Institute, founder of Fantasy SCOTUS, the internet's premier Supreme Court Fantasy League, which you all like. And he blogs at joshblackman.com. He also deals with legal analytics as director of judicial research. And is the author of numerous books and magazines. If you're not familiar with him, you probably have encountered his work. Josh is a frequent commentator on cable networks, in print publications, and magazines, and in law reviews. So we're thankful to have him here to speak about the Consumer Financial Protection Bureau and the constitutional challenges associated with that agency. Thank you.
Thank you. And that sounds like a fantastic Ohio conference. I hope we can all attend. It's a pleasure to be here in Cincinnati. It's my third day here. On Tuesday, I spoke at the Northern Kentucky chapter. We have some of the officers sitting with us today. Yesterday, I spoke at the faculty conference at the Chase Law School. Today, I'm with all of you. When I asked Matt what topic I should cover, I mentioned that I've done some research on the CFPB. And he said, aha, Richard Cordray. So he said, this is the right topic for you. So I understand he's running for governor of your state. You should know a little bit about the guy. So my talk here will focus on Cordray's ruling at the CFPB and the various constitutional challenges to the agency and its structure. So as you may recall, in November 2017, Richard Cordray resigned from his perch as director of the Consumer Finance Protection Bureau, the CFPB. He did this shortly before Thanksgiving when all of you were enjoying your turkey. It ruined my holiday. Now you see, he stepped down not because he completed his 5-year term, but he wanted to run for the Ohio gubernatorial primary, the Democratic Party. But before turning off the lights, he designated Leandra English as his deputy. Now, on its face, this staffing decision may seem unremarkable, but it was far from mundane. Under Cordray's reading of the 2010 Dodd-Frank Act, which established the CFPB, his deputy became acting director upon his resignation. In other words, the Obama era would continue at the agency until President Trump could appoint a permanent replacement. Under the Federal Vacancies Reform Act of 1998, however, the choice of acting director belongs to the president. Now, make no mistake, the person derided in conservative circles as King Richard, as we call him, he precipitated a constitutional clash for no purpose other than to resist President Trump's agenda. But that this is happening at all, that Cordray asserts the power to block the president from naming an acting director, underscores the fact that this all-powerful bureau, which operates outside our separation of powers, is a legal aberration. At bottom, Cordray merely delayed the inevitable. Sooner or later, the CFPB will be restored to a constitutional order under the president's supervision. Thankfully, this conflict will be short-lived, I hope, because Leandra English, or as I call her, the English Queen, her reign came to a brisk end. First, her own agency said she is not the true pope, right? She is not the real leader. They recognize that Mick Mulvaney, who President Trump appointed as the interim head, is the rightful leader. This is a very sad person, by the way. She actually goes to an office every day and does nothing. She just sits at her desk all day. She sends out emails signed director that no one follows. No one listens to her. She has meetings with constituents and she pretends to be the director. It's actually, I think it's quite depressing. She's not getting fired. She's keeping her full salary. So she has basically her office and nothing to do. So this is a very sad person. I pity her. I don't know if she understood. She's not a lawyer. I don't think she quite understood what she was getting herself into. But anyway, she's still in her office every day. They're just leaving her alone, not talking to her. Netflix and chill, I don't know. But it sounds like an awful job. But the second reason why this conflict will be short-lived is that in January 2018, about a month ago, the District Court of the District of Columbia agreed with President Trump and denied English's motion for a preliminary injunction. Now that case is on appeal to the D.C. Circuit. The D.C. Circuit also recently considered the structure of the CFPB. Both of these cases are likely headed to the Supreme Court, and they both pose the same question. How can an independent, agency, see my little scare quotes, how can an independent agency, headed by a single member, with unprecedented authority, exist within our separation of powers? I would humbly submit that it cannot, and I think the court will do something about this. So let's go back to the beginning. You may remember that the CFPB was the idea of one Elizabeth Warren, a senator from Massachusetts, who before being a senator was a law professor. And it was her idea to create this all-powerful agency to protect consumers. Now, this is a good reason why. Never let law professors near power. It's a very... So we had a couple of presidents, Bill Clinton, Barack Obama, do not let law professors near power. It's a funny story. When Bill Clinton was teaching common law at the University of Arkansas, he once lost the final exams. She lost with no idea where they were. Oh, God. Totally lost the papers. God knows what he was doing with the students, right? So he lost the papers. So anyway, keep common law professors far, far away from power. But Warren was blocked from being the head of this agency. So instead, the Democrats and President Obama picked Richard Cordray, who was a longtime Ohioan and a Jeopardy champion, among other things. Now, Cordray's tenure began as it ended, with a slight of the Constitution. In 2012, following the enactment of Dodd-Frank and the creation of the CFPB, Republicans filibustered Cordray's nomination as inaugural director. Undeterred, President Obama purported to appoint Cordray, as well as several members of the National Labor Relations Board, during a 72-hour recess of the Senate. And I put these scare quotes because they weren't actually recess. At the time, Obama said, "I refuse to take no for an answer." But in 2014, the Supreme Court told him, no. All 9 justices ruled that the appointments were unconstitutional and that a 3-day break was too short to trigger the president's recess powers. The same reasoning applies to Cordray's tenure, though it was not challenged in this case. When even Justice Ginsburg, by the way, turns 85 today, it's her birthday, happy birthday, Ruth, right? When even Justice Ginsburg agrees that President Obama violated the separation of powers, you know you are in trouble. And Cordray's tenure began on the flimsiest footing. Now, eventually, Republicans confirmed Cordray as part of a pact to keep the filibuster on the table. Remember this? Well, that rapprochement was short-lived, as Senator Reid would trigger the so-called nuclear option, which allowed President Obama to put 3 nominees on the all-important D.C. Circuit. By the way, those same 3 judges voted to uphold the constitutionality of the CFPB. See, everything's connected. Everything goes back to Cordray, right? It's all in the same constellation. Now, once installed in his office with a 5-year term ahead of him, Cordray issued a statement that said, "All of my previous actions during his illegal tenure were, quote, legally authorized and entirely proper." But he added, "To avoid any possible uncertainty, I hereby affirm and ratify any and all actions I took." In other words, I wasn't legally appointed, but I'm reaffirming it all now, so now it's all good. That's not how it works. The emperor had no clothes at that point. So early on, it became clear that Cordray would expand his agency's authority to regulate wide swaths of the economy with zero accountability to the executive branch, or for that matter, the separation of powers. Indeed, the entire structure of the CFPB is a legal aberration. The Constitution provides that the executive power should be vested in a president of the United States. But the president was never expected to, nor could he do all the work by himself. Since the earliest days of the Republic, Congress created by statute various departments and established officers to manage them. For example, the first Congress established the Department of Treasury. And as we all know from Broadway, President Washington nominated Alexander Hamilton, right, to be its first secretary. Once confirmed by the Senate, Hamilton then had the authority to take care that the duties were faithfully executed. But it was long understood that agency heads served at the president's pleasure and could be removed at any time for any reason or no reason at all. This settlement would be challenged following the Civil War. when President Andrew Johnson fired President Lincoln's holdover Secretary of War. The House of Representatives impeached Johnson over this decision, charging that he needed Congress's permission to remove this principal officer. As history recounts, the Senate acquitted Johnson by a single vote. But the constitutional question lingered. In 1926, the Supreme Court ruled in Myers v. United States that President Johnson was correct, and the president's removal power was unfettered. Congress could not put strings on it. Such was settled law for barely a decade, when in 1935 the court decided Humphrey's Executive versus United States. This decision blessed the so-called independent agencies, I'll say independent in scare quotes again, such as the Federal Trade Commission, which was headed by 5-member boards. These agency heads, 3 of the president's party, 2 of the opposite party, can be removed only for cause, such as neglect or malfeasance, not at the executive's pleasure. Although the president can appoint a majority of the commissioners, there is no guarantee they will advance his agenda, and such is the rub of independent agencies. Judge Brett Kavanaugh observed for a panel of the D.C. Circuit, now vacated opinion, that these independent commissions are in effect a headless 4th branch of the U.S. government that, in the absence of presidential supervision and direction, can, quote, pose a significant threat to individual liberty and to the constitutional separation of powers and checks and balances. What pulls these agencies back from the constitutional brink, the Supreme Court has told us, is they have historically been headed by 5-member commissions, the proverbial body of experts. Through collaboration, they can reduce the risk of arbitrary decision-making. The correctness of Humphrey's executor, often viewed as a rebuke of President Roosevelt, is a matter for another day, but I'll say it's settled law. Wrong, but settled law. Enter the CFPB. Following the financial crisis of the late 2000s, President Obama and congressional Democrats sought to make a truly independent agency to protect consumers and financial markets. As a matter of policy, we can debate how laudable that goal is. As a constitutional matter, the CFPB is neither fish nor fowl. It is headed by a single director who can be removed only for malfeasance. Traditionally, if a single person heads an agency, that person is not removable at will. Is removable at will, while members of commissions are removable only for cause. The CFPB is a freak hybrid that combines both attributes in a single powerful position. Judge Kavanaugh wrote for the D.C. Circuit, no independent agency exercising substantial executive authority has ever been headed by a single person, until now. Faced with this unprecedented authority, the 3-judge D.C. Circuit ruled that CFPB was unconstitutionally structured, though they divided on the remedy. Judges Kavanaugh and Randolph stopped short of striking down the entire agency. Rather, they saved the law by holding that the president could remove the director at will. Judge Henderson, who dissented in part, would have resolved the case on narrower statutory grounds. That decision, which I think was correct, did not stand for long, as the majority of the judges in the D.C. Circuit voted to rehear the case. After the election, DOJ reversed its position. The Trump administration now agreed with Judge Kavanaugh that the director must be subject to the president's removal. Cordray would now defend himself in court, which brings us to the most recent developments. On January 31st, about a month ago, the en banc D.C. Circuit upheld the CFPB structure by a vote of 6-3. The margin of victory, the 3 judges who were nominated alongside Cordray. These things matter. There were 7 separate opinions. The opinion was almost 250 pages in length. Remarkable. Judges have nothing better to do, right? They make us read this stuff. Judge Pillard wrote the opinion for the court. Judges Tatel, Millett, Wilkins, and Rogers concurred in that opinion. Judge Griffith concurred in judgment. The 3 members of the original panel, Henderson, Kavanaugh, and Randolph wrote separate dissents. I won't bore you with the details of the entire 250-page opinion, but I will recite some of the highlights from the opinions of Judge Pillard, Judge Griffith, and Judge Kavanaugh in dissent. First, Judge Pillard's opinion found that the CFPB structure was supported by Humphrey's executor. She explained that historically, agencies could either have a single head or a multi-head agency. She says nothing in Humphrey's executor limited the analysis to the fact that there was a multi-member directorate. She's not wrong about that point. There is an agency called the Controller of the Currency, which is fairly obscure. No one cares about it. But it's a single-member agency that's not removable at will. So there are some examples of instances where they have a single-member agency with for-cause protection. I say kill those also. Those are probably unconstitutional as well. Okay? So she writes, Judge Pillard, that even though it's unprecedented, the CFPB, that doesn't render it unconstitutional. In fact, she cites the Chief Justice's opinion in a case that breaks my heart every year, the Obamacare decision. Chief Justice Roberts, she wrote, even if the CFPB were anomalous, that doesn't prove anything. Novelty is not necessarily fatal. There's a first time for everything, wrote Chief Justice Roberts. And there were two very different conceptions of liberty on display between the majority and the dissent. Let me read you an excerpt. Judge Pillard wrote, another leap by the challengers is the assumption that the CFPB challenge characteristics diminish liberty writ large, she adds. It remains unexplained why we would assess the challenge removal restriction with reference to the liberty of financial service providers and not more broadly to the liberty of individuals and families who are their customers. And this is a strange notion of liberty. The idea that restricting private enterprise is not liberty, but government oversight is liberty. It's a very foundationally different definition of what freedom is that the left and the right, I don't think, see eye to eye on at all. Liberty is the absence of government, not the addition of government. And this part, there's no overlap. Now, Judge Griffith, who's a very smart judge, he used to be a Senate counsel, wrote a different opinion occurring in judgment. And what he said is this: the director can be removed for, quote, inefficiency, neglect of duty, or malfeasance in office. Griffith said that's not really that hard to prove. The president can decide that this standard is satisfied when the director makes inefficient policy choices. That is, if the president decides that the director made a bad policy decision, that is grounds for removal. If Griffith is right, then basically all for-cause protection is now worthless, right? For-cause protection means nothing at all because the president says, you know what, you made a bad decision, you're fired. How is it any different than at-will employment? It's really not. So part of me thinks that the court will adopt the Griffith opinion because it gives the easy way out. You can read the for-cause provision narrowly. But if they do that, they basically render all principal agency heads removal basically at will. Then is there any insulation, right? If this is right, and you can remove for ineffective policy choice, then you can fire any commissioner at will. So Griffith's opinion is appealing. I go back and forth whether I think the court will adopt it. I don't know. Because if the removal standard is so lenient, it basically becomes at will. And independent agencies are not very independent anymore. Then we come to Judge Kavanaugh's dissent. This was his Supreme Court edition, right? This is you have an edition tape. This is his audition tape. He believes he's just saying this because he really turned it up for this one. Kennedy writes. Let me read this excerpt. He's a wonderful writer. I'm mostly joking with him. I like his stuff, but this was red meat. He says, "This is a case about executive power and individual liberty. To prevent tyranny and protect individual liberty, the framers of the Constitution separated the legislative, executive, and judicial powers of the new national government. To further safeguard liberty, the framers insisted upon accountability for the exercise of executive power." Okay? Continues. The framers lodged full responsibility for the executive power in a president of the United States who is elected by and accountable to the people. He then cites Justice Scalia's famous dissent in Morrison v. Olson, the independent counsel statute. The purpose of the separation and equilibration of powers in general, and of the unitary executive in particular, was not merely to assure effective government, but to preserve individual freedom. Now, usually when you're a Court of Appeals judge, you're not citing dissents from Supreme Court opinions. But Scalia's dissent in Morrison v. Olson is the right opinion, right? This was the case of whether Congress can approve of an independent counsel who can prosecute members of the executive branch and was not removable at will. The court upheld that prosecution 8-1. And only Justice Scalia dissented. And he had this wonderful dissent, where he said very often in separation of powers cases, you have these disguised violations, so to speak, the wolf in sheep's clothing, where on its face it looks fine, but it's really dangerous. But Scalia said, one of my favorite quotes of all time, this wolf comes as a wolf. I miss him. You're going to have fun with Ed Whalen next month. He's wonderful. He's a former Scalia clerk. But Kavanaugh is channeling Scalia's dissent, perhaps hoping there are 5 votes to agree with Scalia. Maybe there are, maybe there aren't, I don't know. Kavanaugh continues, the heads of executive agencies are accountable to and checked by the president. And the heads of independent agencies, although not accountable to or checked by the president, are at least accountable to and checked by their fellow commissioners or board members. But the CFPB is different. No independent agency exercising substantial executive authority, keyword substantial, whatever that means, has ever been headed by a single person until Richard Cordray, until now. So this is very Scalia-esque, but I think it's risky when you are citing the dissent in a case. But I think the dissent's correct in this case, but the Kavanaugh went on a bit of a limb there. So for now, at least, the CFPB structure was upheld. Let's go back to Miss English, the woman who sits in her office watching Netflix all day. I don't know if she's actually watching Netflix, but I don't know what she's doing. If I were her, I would turn off her Wi-Fi and see how that works for a day. We'll see. She can't Netflix and chill for all day. Now, as had long been expected in mid-November, Cordray announced he would resign from the CFPB. Trump announced he would appoint OMB Director Mick Mulvaney to serve as the acting head until a full-time director is nominated. This is allowed under the Federal Vacancies Reform Act, which says if there's a vacancy because of resignation, the president can take another person who's been confirmed by the Senate and put him in. Mulvaney had been confirmed by the Senate. So in the normal course, Cordray would have stepped down and allowed the president to fill the slot, both temporarily and permanently. But we are not living in normal times. Instead, on November 24th, hours before he stepped down, Cordray tapped this woman, Leandra English, as his deputy director. That position had been empty for years, and he only thought to fill it a few hours before he resigned, right? In a separate memo to his staff, Cordray declared that upon his resignation, English would become the acting director. His rationales were at once transparent and naked. He wrote, in considering how to ensure an orderly succession for the independent agency, I, King Richard, determined that it would be best to avoid leaving this key position filled only in an acting capacity. Appointing English for this position, he wrote, would minimize operational disruption and provide for a smooth transition. Balderdash. Trump had already announced his intent to tap Mulvaney as director. Cordray's justification was to ensure that the Obama-era admission would continue, even with the new administration in town, insisting that he, King Richard, and not the president gets to decide the orderly succession for this agency underscores how right Judge Kavanaugh was. Alas, like Sally Yates before him, Cordray could not simply resign. Instead, he sought to resist President Trump and make it as hard as possible for the incumbent president to implement his own agenda. Again, on November 24th, shortly before he resigned, Cordray appointed English as his director, as deputy. That same day, Trump tapped Mulvaney to head the CFPB. What happened next? Litigation. The next day, the DOJ's Office of Legal Counsel issued a memo confirming that it gave advice to the president. The president was permitted to designate an acting head under the Vacancies Reform Act. That same day, though, the general counsel of the CFPB, again, the general counsel was appointed by Cordray, reached the same conclusion. Cordray's own lawyer agreed with the Trump DOJ. Right? You're in trouble, Miss English. And then in a conference call, the directors of the CFPB's different divisions throughout the country said, we agree that Mulvaney was the acting director. But you know what actually settled it, right? Twitter. So Mick Mulvaney registered the handle on Twitter, CFPB director, and it got verified. It got a blue check mark. So Twitter blessed Mick Mulvaney with the definitive directorship by saying, you are the true director, because they give you a little blue check mark to verify your account. If you don't know what that means, I'll explain it later. But this is a big deal on Twitter when you're verified, okay? At this point, poor Miss English was only director in her own mind. She would even send out emails signed acting director. No one follows her, except there was a group of employees of the agency, I'm not joking, this is serious, who called themselves Dumbledore's Army. I'm going to read you a quote from the New York Times so you know I'm not making this up. One small group calls itself Dumbledore's Army. The name is a reference to a secret resistance force in the Harry Potter books. An atmosphere of intense anxiety has taken hold. Several employees said, in some cases, conversations between staff that used to take place by phone or text now happen almost exclusively in person or through encrypted messaging apps. I want you to understand this. Government employees who work for, I think, us, right? I think they work for us, I suppose, were paid a salary of taxpayer dollars, called themselves Dumbledore's Army, because they're referencing the Harry Potter books, where the students at Hogwarts, following Dumbledore, the professor, were resisting the evil forces of Voldemort at Hogwarts. They're comparing themselves to fictional characters in fantasy books to try to resist Mulvaney. And instead of using channels where their emails can be found, I guess you're taking the lead from up top, right? Using encrypted messaging apps. Right? Hillary should use that, right? They're using encrypted messaging apps. That way their private tech messages won't get hacked. It's insane. I don't know what to do with this, but these people are working. I hope that the resistance has faded. Viva la resistance, right? I hope it's faded. In any event, Mulvaney showed up for work on Monday the 27th after all this happened, and he was given access to the director's office. I tweeted time, he should just lock her out of the building, but that might give her a cause of action, so he didn't lock her out of the building. He should have just locked her out. I think that'd be appropriate. He brought donuts with him. People like donuts. So as far as everything goes, he's a director. He has the office, right? People call him director. He has a verified Twitter account. What else is there, right? English went to federal court. She sought a temporary restraining order, a TRO, to prevent the president from appointing any director other than her, to force the president to withdraw Mulvaney's appointment, to prohibit Mulvaney from serving, and also to declare invalid any action he took. That's a key point, right? It doesn't matter who has the keys. If he takes an action when he's not properly appointed, it's ultra vires. Now, the case was assigned to Judge Kelly, who was a recent Trump appointee. He denied the TRO, denied the temporary restraining order. Now, English then moved for a preliminary injunction, which was also denied. So first, the court held that the Federal Vacancies Reform Act authorizes President Trump to install an acting director. Not controversial. Second, the court held that Dodd-Frank, which is a big consumer protection law, did not displace the Federal Vacancies Reform Act, right? Even though the statute said the deputy director shall be appointed by the director, that would be Cordray, there is no conflict, and the Federal Vacancies Reform Act remains as an option for the president. After a thorough treatment of various canons of construction, the court closed with the important canon of constitutional avoidance. Let me read this part from Judge Kelly's opinion. He said, under English's interpretation, however, Cordray could have named anyone the CFPB's deputy director, and the president would be virtually powerless to replace that person upon ascension to acting director. no matter how unqualified that person is. By the way, English is not qualified to an agency. She's in her mid-30s. She's not a lawyer. Apparently, people think she got the job because she was Cordray's friend, right? She's not actually qualified to be in this position. The court wrote, that alone threatens to undermine the president's ability to fulfill his take care clause obligations. Ultimately, the court need not decide whether English's interpretation of Dodd-Frank comports with the Constitution. The court notes only that it poses a serious constitutional problem and that the canon of constitutional avoidance operates to confirm a conclusion that the Federal Vacancies Reform Act is available to the president that would have otherwise been commanded by the text of the statutes and other principles. Okay? In other words, if Cordray is right that Trump can't put in his own person, that very likely might violate the take care clause, the president's duty to take care that the laws are faithfully executed. Third, the court rejected English's argument that Mulvaney, who is also the head of the Office of Management and Budget, cannot serve as the acting director of an independent agency. That is, someone working in the White House can also head a, quote, independent agency. Why do I keep saying independent? It's not a real thing. You can't have an independent agency. It doesn't exist. The court wrote, this argument is completely without support in the text of Dodd-Frank, and the court declines to create such a restriction out of whole cloth. Okay. The term independent bureau, without more, says nothing about who can serve as the acting director. Finally, the court said the equities do not balance English's direction. Granting English an injunction would not bring about more clarity. It would only serve to muddy the waters. Right? Having two popes is very bad. Therefore, the balance of the equities and the public interest weigh against the injunction. Now, the D.C. Circuit, at some point soon, will have to determine who is the correct director. Is it Mulvaney or is it English? I don't know if Mulvaney loses his blue checkmark on Twitter if he loses. They have to take out the verified account, but we'll see. But here, my friends, I'll finish up on this point. The tiebreaker must be the separation of powers. Reading Dodd-Frank, as Cordray does, crystallizes the constitutional abomination that is a CFPB. The president can't remove the director unless the latter engages in some act of malfeasance, and the president is utterly powerless to appoint an acting director as well. No, this cannot stand. Cordray, a former Jeopardy champion, should know the appropriate decision maker here, who is the president. Perhaps the most unfortunate aspect of this entire ordeal is that once President Trump's permanent CFPB nominee is confirmed, this tempest in a teapot runs out of steam. The controversy will be moot, and whatever case law might be developed during this interregnum will ultimately be vacated under what's called the Munsingware Doctrine. Thousands of pages of briefing will be for naught, and that nullity is precisely what King Richard's final act has wrought. Thank you all very much. I welcome your questions. Yes, sir.
Is the Federal Reserve Board, aren't they pretty much an independent agency, and as far as being governed, they're not really part of, they're like neither fish nor fowl either, are they?
Yeah, so the Federal Reserve is very unique in that their funding is not by Congress. They basically have their own independent funding source.
So the CFPB was.
And the CFPB exactly derives from the Federal Reserve. The only difference is the Federal Reserve is a multi-member board, right? The president can appoint members to the Fed. He can't appoint members to the CFPB. He has only one director. I have doubts about the Federal Reserve's independence also, but that's not an issue in this case. But the big difference is the Fed has multiple members who can check each other. Here, King Richard acts alone, or now Queen English, or whatever her name is. For the English Queen. Other questions? Yes, sir.
Under Humphrey's executor, they place a lot of emphasis on this being a nonpartisan office, a body of experts.
Yep.
Nobody really believes that anymore, that that's a possibility. So do you think the Supreme Court is maybe going to take that to say, you know, whatever people thought about things like that back then, you know, today that's not going to hold water, and especially when you've got one person, obviously.
Right. So again, the Humphreys executor case involved a case from the New Deal, where President Roosevelt asked a commissioner of the Federal Trade Commission to step down. Roosevelt gave no reason. He said, I want to put my own guy in there. And he refused to resign, so then Roosevelt fired him. Humphreys, a guy named William Humphreys, sued for his back pay, to get back pay out of it. He actually died during the course of the litigation, so actually his estate continued to sue for the back pay. It's called Humphreys Executive. I actually have his death certificate if you're interested. He died of a heart attack. Someone sent it to me. Right? I get weird stuff as a professor. Someone sent me his death certificate. Whatever. Arterial sclerosis, to be precise. But the court, in probably a rebuke to Roosevelt, held that for these independent 5-member boards, the president can't remove at will, that he needs to follow the terms of the statute. One of the reasons why they stress this independence is the body of experts provision, right? That because these people are objective policymakers, they need to have protections. Now your question is, does anyone actually believe that? Of course not, right? You know, I don't think it makes any difference really if it's a 5-member or 1-member. The Republicans members will do one thing and the Democrat members do the other. There's very little actual checking and balancing. So Humphreys Executive creates a bit of a fiction. It's a fiction that you'll have this checking. It doesn't really matter. But I will say that at least having 5 members is more of a check than 1 member, right? So there's a bigger leap from a body of experts to a single expert who wields independent authority. I'll give you an example. When you have a 5-member board, you have majority and dissenting opinions. And the dissenting opinion can actually highlight that there's some sort of debate. When Cordray issues a rule or pursues litigation, there is no dissent. It's just him. So even if the 5 members of the board don't actually have this balance, they at least publicize the decision-making process. With Cordray, it's, I'm going to sue you, and I'm going to sue you, and that's all there is to it. There's no check on that. Thank you for the question. Yes, sir.
Back to the Federal Reserve, not its constitutionality, but the fact that CFPB is funded by the Federal Reserve and does not get its money from Congress, and therefore Congress cannot check it through its spending power. That, Professor, I think, would be another argument why it fails.
It is, and this came up in the litigation concerning the D.C. Circuit. If the agency doesn't need to ask Congress for money, and the directorate can't be removed at will, it's accountable to neither branch. It's really this aberration that's neither fish nor fowl. And I think that that alone, that it doesn't need to go to Congress for money, renders it inconsistent with their separation of powers. The Federal Reserve gets their money from, I guess, fees from various agencies that it regulates. Is that the idea?
Or it prints it.
Yeah, I'm sorry?
Or it prints it.
Prints it. Yeah, well, yeah, I guess they can print their money. I suppose that's true. But I do think that the entire structure of this agency was designed to make it impossible for future presidents to check it, and that simply cannot be the case. But yeah, audit the Fed, right, Ron Paul. Question on this side? I'll go back to you, sir. Go ahead.
One of the things that the CFPB did, and again, because I'm in the title insurance industry, they had a big ruling and a big fine against, again, as violations of one of their regulations, and they hit a $100 million judgment, I guess. And I think that had been reversed. But the fact that CFPB was in effect getting its money by suing people and shaking them down.
Shaking them down, sir. Have you no shame, right? Have you no decency. You're right. Yeah.
And that had anything to do with any of this ruling, or it has that?
Well, another aspect. I'll answer your question in 2 parts. So the question was about the various lawsuits. Usually, when you have an administrative agency, they develop regulations through the notice and comment rulemaking process, which at least in theory, people in the public are open to comment on. The CFPB did something very different. They would just sue people, and when they got a judgment, that was a new rule. So you didn't know you were violating the law until you got sued, right? You thought you were complying with the law. Aha, you get sued based on some nebulous interpretation of a 4,000-page statute that no one bothered reading when they voted on it. So Cordray had independent litigating authority, and that's important, right? He didn't need to go to DOJ to file a lawsuit. He could just sue and challenge people by himself, which allows for the shakedown the gentleman referenced. And by the way, whatever money they got, they augmented their own budget. And this is one of the highest budgeted agencies in DC per capita, right, per employee. Their budget's through the roof because there's no oversight. They don't need to go to Congress, like, here's our budget. So the entire structure renders it without any possible oversight. Yes, sir.
Just a general question that's sort of related. Question of how to rein in the administrative state. What would you say the top 3 things are that can be done? I know there are constant conferences with the Federal Society, law review articles, commentary. Charles Murray thinks it's hopeless. You know, he's moved on.
So, all right. So the question is, how can you rein in the administrative state? There is some glimmers of hope. I come here bearing gifts, right? So there's a doctrine which you probably studied in common law called the non-delegation doctrine, right? This is the idea that the legislative power belongs to Congress, and it can't be given to the president. The non-delegation doctrine had two good cases in 1935. Panama Refining Company and Schechter Poultry, where the court held that Congress gave the president too much authority and there was not a sufficient intelligible principle. The past 75 years have not been good for this doctrine. The courts have basically looked away. Not even a week ago, the court granted cert in a case that raises non-delegation problem issues. The statute, I'll summarize it, gives the Attorney General the discretion to designate certain people sex offenders. There's not much discretion, not much guidance on that as well. And the court granted cert of whether this criminal law violates the non-delegation doctrine. This is significant because Judge Gorsuch, when he was on the Court of Appeals, ruled that it probably would. So he's thinking about this. His clerks managed to get a cert grant on this. Kudos to his law clerks on this for pulling it out and hustling on this. And the court might find a criminal case to peel back elements of the non-delegation doctrine. Now, we're not going back to the pre-New Deal. I don't think that's even possible. I'd be happy to just slow down the road to serfdom. You can't stop it. Right? We're still rolling, but just put some rocks in the road just to make it a little bit more bumpy. And I would be content with that. But I think there's hope in terms of the Chevron doctrine, which I'm sure you're aware of. This doctrine says if a statute's ambiguous that Congress enacts, of course we'll just basically defer to whatever the agency wants as long as it's not insane. There have been some judges who have expressed skepticism of Chevron, saying that this is an abdication of the judicial power. So, look, I don't think things are awesome, but there's some glimmers of hope. There's some rays of hope. Had Justice Gorsuch not been appointed, had we have Justice Garland or someone else, I might be a little more dour, maybe wearing all black instead of just a black suit, mourning the Constitution. Just throw it in, go learn like tax law or something, I don't know. But no offense to tax law. Got tax lawyers in the room, I'm sure, but I would consider perhaps moving to a different line of work if the court had gone otherwise. Thank you for the question. Tax lawyers are great. I learned all about tax law with Obamacare. I've had to read more Internal Revenue Code than I ever wanted to. Okay, other questions?
Ms. Funny, make more
Number one, number two? Go ahead.
Why don't you talk a little bit about timing? You mentioned that the DC court is going to make a decision here. Do you have any idea when that's going to occur? And then we've got the governor's election coming up here.
Oh, right. So when's the primary? When's the primary?
May 4th.
May 4th?
Yeah, I was just wondering. Good question.
I doubt the district court opinion was on January 30th. I'm doubtful we get a decision by May 4th. I mean, it's possible. It might be argued like in April, but I doubt you'll get a decision that quickly. So I don't think you'll have an opinion there in time for the primary. Do you think it would actually hurt Cordray? You guys are local. If he gets ruled against, would that hurt his chances in the primary? Would that bolster him? These Trump judges are ruling against him. I don't know how that cuts. You guys are
There's been no discussion of it at all, as best as I can tell.
I don't think anyone cares. It's a fairly obscure issue. It took me 30 minutes to explain it to you. It's not an obvious issue of why he can't do this. Right? I had to give you a lot of background. In fact, I think if they rule against Cordray, it probably would embolden him, saying, aha, we need to fight back against this Trump judges and everything else. Yes, we hear the question?
Have the plaintiffs in the PHH case, in the D.C. Circuit inmate case, said whether they're going to file for cert or not? Because didn't they get the main kind of big fine thrown out on other grounds, but then they lost on this single director point, so it's not clear whether they're going to keep going.
Very good question. It's a very good question. So, the challenge to this CFPB structure was brought by a lot of different groups. There are lawsuits across the country. This was a financial outfit called PHH, I don't know what it stands for. And they were assessed a fine, there was a RESPA, I think.
Something like that, yeah.
They were assessed a fine under this bizarre regime. And they said that we can't be assessed as fine because the CFPB director was not properly appointed. The DC Circuit en banc, Judge Pillard, is something very crafty. She ruled that the structure of the agency is valid, but that the fine was improper. So she killed the fine. So PHH is a prevailing party. Can they even file a cert petition? I think they can. There's a case called Camreta versus Green. So the non-prevailing party can still file a cert petition. Better question is, do they want to? Right? You're all lawyers. Your client just got a multi-million-dollar fine killed. Are you going to roll your dice at the Supreme Court or just walk away and take your victories? I mean, look, they're not here for ideological purity. They got a fine. They were trying to challenge it. But the good news is there are other cases in the pipeline, right? So if it's not PHH, it'll be someone else. Someone will just stipulate the judgment and be done with this. So my prediction is the court gets a CFPB case at some point next year, and they'll do what they're going to do. I can't imagine them killing the entire agency. They might try and strike the for cause provision, in which case it's basically an at-will position. But you may have some concerns that weakening Humphrey's executor and weakening Morrison versus Olson may play into the affair of Mr. Robert Mueller, who you might be aware is appointed in a very strange fashion. So anything the court says in this case will necessarily implicate Mueller. Who knows, by then we'll have a new Attorney General. We might have one tomorrow, I don't know. President Trump might just tweet saying, no, we have a new Attorney General, right? You know, forget the smoke in the Vatican for a little chimney, we'll just tweet. You know, we have Habemos Papam, right? Hashtag Habemos Papam, we have a pope. When I get tenure, I'll tell my dean, just tweet it, don't even call me, just tweet, Josh got tenure. Good. Other questions? Anything else?
That's it.
Thank you all so much for your attention. I appreciate it.
Thank you, everyone.